Welcome everyone to the launch of the NYU UNEP report entitled The Right to Healthy Environment, a Decade Before the Courts. By way of introduction, my name is Melina, and I served as a director attorney at NYU's Earth Rights Research and Action, or TERRA program, where I led the Right to Healthy Environment project and where I had the honor of co-authoring this report. More generally, my work has centered on the right to a healthy environment, the nexus between human rights and climate change, and legal personhood of the more than human world. Timing could not be any better, as today marks the fourth anniversary of the UN Human Rights Council resolution recognizing the right to a healthy environment as an international human right, providing momentum for the General Assembly resolution that followed soon after, and further solidifying the right's legal weight. As many of us are aware of, the human right to a clean, healthy, and sustainable environment is not a new human right. Its foundations actually lie in various indigenous legal systems, and countries around the world have recognized the right at both national and subnational levels since the early 1970s. This means, lucky for us, that efforts to implement and improve compliance with the right are not starting from scratch, and that a vast, complex, and growing universe of legislative and judicial practice surrounds the right. Seeing this, NYU and UNEP came together to create the Right to a Healthy Environment Toolkit, the first ever database of recognition of the right to a healthy environment and case law analysis. Now, it's important to note about the toolkit that rather than serving as a comprehensive repository of all right to healthy environment related jurisprudence, the toolkit curates significant, and that is defined as decisions by domestic, regional, and international judicial or quasi-judicial bodies that have made notable contributions to the doctrinal development of the right. This includes decisions that advance, limit, or otherwise engage substantively with the right. Now, in light of the profound environmental transformations of the past decade, coupled with the momentum in the recognition and jurisprudential development of the right to healthy environment, the joint report that we launch here today draws from the toolkit to examine developments in the interpretation of the right between January 2015 and July 2025. Just a few notes on the analysis and the methodology. The analysis includes over 100 decisions that are legally significant, which, as I have just mentioned, means relevant to defining or shaping the evolving understandings of the scope and content of the right. The dataset spans over 30 countries and includes decisions from a range of international and regional human rights bodies. The petitioners in the cases covered by the report represent a diverse array of actors, including civil society organizations, indigenous peoples, as well as children and youth, while the respondents are primarily governments as well as private sector actors. As you will see once you read it, the report is structured around both emerging trends and possible trajectories for the future development of the right. In particular, the report distinguishes between, number one, emerging trends, which we will primarily focus on today, and which are repeated legal developments across jurisdictions that suggest the consolidation of a broader shift in how the right is interpreted, and, number two, signals of change, which are earlier stage developments or innovations that may influence future interpretations of the right. Overall, the report focuses on how courts have employed the right to more effectively address the triple planetary crisis of climate change, nature, land, and biodiversity loss, and pollution and waste. You can find the report in the Right to Healthy Environment Toolkit and in the link in the chat, as well as the UN website. And we will make sure to disseminate the report widely after the event as well. Now, before turning to our speakers, I would like to remind you, the audience, to input your questions in the Q&A chat throughout the panel. We have reserved the last, hopefully, 15 minutes for the questions, and if not, we'll try to get them back at you after the event. So I now turn to our panelists who have had the pleasure to work closely with in the past. I'll introduce them first, and then we'll get started. So Justice Syed Mansoor Ali Shah. Justice Shah was elevated to the bench at the Lahore High Court in 2009 and after serving as the Chief Justice of the Lahore High Court for almost 2 years, was elevated to the Supreme Court of Pakistan in early 2018. As a corporate litigator, he was a partner at Afridi, Shah, and Minala, and took keen interest in public interest litigation with special focus on environmental issues and sustainable development. He has espoused a passion for teaching and taught law for almost 2 decades. His areas of special interest are constitutional law, human rights, climate and water justice, environmental sustainability, disability rights, criminology, digital surveillance, privacy, and proportionality, among many, many others. Thank you very much, Justice Shah, for being here today.
Thank you.
Now I turn to Soo-Young Hwang. Soo-Young is a legal officer with the UN Environmental Program, UNEP, where she works in the advancement and implementation of environmental rule of law and environmental rights. Prior to joining UNEP, she worked with the UN Office of the High Commissioner for Human Rights, working on economic, social, and environmental issues. She holds a PhD in international relations, specializing in states' compliance with international law and norms. Soo-Young has worked very closely with states, civil society, environmental activists, and academia on the recognition of the right to a healthy environment. Thank you, Soo-Young, also for being here. And now, last but not least, Cesar Rodriguez-Garavito. Cesar is a professor of law and chair of the Center for Human Rights and Global Justice at NYU School of Law. He's a founding director of the NYU Right to Healthy Environment Toolkit and the Terra Clinic and Program. Professor Garavito is an earth rights and human rights scholar and a field lawyer whose work focuses on international environmental law, indigenous peoples' rights, and the more than human rights. His latest book is Climate Change on Trial: Mobilizing Human Rights Litigation to Accelerate Climate Action. As with our report today and all of Terra's work, this is an open source book which you can find online. So with that, I will get the panel started. So I'm first going to refer to Soo-Young to set the scene. So Soo-Young, as I explained in the introduction, both the recognition and the jurisprudential development of the right have gained momentum in the past decade. So, given UNEP's leading role in promoting the recognition and effective implementation of the right to a healthy environment, could you elaborate on how formal recognition of the right reinforces its jurisprudential development and vice versa? Maybe if you can give us some examples of recent developments in either the recognition or the jurisprudential development that you would like to point to, and why are both dimensions important for advancing the right in practice?
Thank you very much, Melina, and very, very happy to be here. And also wanted to, so I'm representing UNEP, but I also wanted to thank my colleagues in UNEP who was like really instrumental in the development of the report, along with the NYU colleagues, Melina and Cesar. So that's Juliana Almeida and Sushmita Patel. So thanks so much for the question on this linkage between the jurisprudential development and also the formal the recognition of the right to healthy environment. So in short, as this is one of the findings from the report, this is that relationship between the two has been mutually reinforcing. So the formal recognition of the right and the jurisprudential development has been like having positive influence for each other in the recognition as well as in the development and understanding and applying the right to healthy environment. So maybe we can take a step back to see like how the recognition has the status of the recognition of the right to healthy environment. So as of at the time of publishing the report, we have 165 countries recognizing the right to healthy environment, bringing the number to a very, very big number, over 80% of the UN member states recognizing the right. So at the national level, regional level, and also the culmination of the recognition of the right as now we know why we are here as well was the UN Human Rights Council resolution that was adopted 4 years ago today, and also subsequently recognized by the UN General Assembly in 2022. So those two recognitions of by the UN has really brought up the formal recognition of the right as an international and also universal human right, and which has been cited in climate, biodiversity, and chemicals pollution agreements, environment agreements since then. And this formal recognition has guided the courts to treat right to a healthy environment as a fundamental human right and to expand the remedies and obligations accordingly, as elaborated in the report. And what about jurisprudence? How that drove a further recognition and that gave more meaning to the right to healthy environment. So domestic, regional, and international courts have used the formal recognition of the right to further recognize and advance the right. So, for instance, when states were negotiating for the Council resolution and GA resolutions, some states have cited national jurisprudence when supporting the UN recognition, which is quite interesting. How you can see the domestic level of recognition by the courts is really pushing for the has really pushed for the formal recognition by the UN at the global level. And since then, also courts have increasingly drawn on formal recognition to affirm, interpret, and clarify or enforce obligations relating to the right to healthy environment. So the key ones, it was really a good timing that the ICJ, the International Court of Justice, published this advisory opinion in time for our report in July this year. So in ICJ report, ICJ advisory opinion, it's one of the key takeaway for the right to healthy environment is the court recognized right to healthy environment is as an essential for the enjoyment of other human rights. And another international level of courts driving giving meaning and clarifying and also reaffirming the right to healthy environment is the Inter-American Court of Human Rights. And in 2025, it used a UN resolution to clarify states' climate obligations. And also that happened at the regional level, European Court of Human Rights, in a case of Switzerland and the collective action of a senior woman. And it invoked in the interpretation, it invoked UNGA resolution 2076/300 to interpret the European Convention on Human Rights harmoniously with international law. And also at the national level, we have observed that Constitutional Court of Colombia and Costa Rica cited the UNGA resolution to treat right to healthy environment as a fundamental and autonomous right. And also, we've seen many cases of India's Supreme Court, and also we've seen it's not a court, but also the Committee on the right to CRC, Committee on the Rights of the Child, has also affirmed children's right to healthy environment in its general comment. So it has been really seen the key. It's the recognition and the jurisprudence advance together, and each strengthened each other's legitimacy and scope and the enforcement. And formal recognition provided the normative foundation, and the jurisprudence gave the right concrete meaning and applicability, but also the further concretize the status of the right to healthy environment. So in this regard, this relationship expands both acceptance and implementation of the right to a healthy environment. So why both dimensions matter in practice, and why do we need a formal recognition, and why do we need a jurisprudence advancement? So it's because like together they transform the right from principle to practice, building the legal architecture needed for a healthy and sustainable planet for everybody. So together in practical terms, like they establish the universal norms and bringing precedents for implementation and ensure the coherence between global, regional, and national levels, and enable the courts and policymakers to address the triple planetary crisis through a human rights lens. And finally, it also strengthened access to justice and accountability related to the right to healthy environment. So
Wonderful.
this has like really the mutually reinforcing relations that we have found in the report, and I'll stop here. Thank you.
Thank you, Soo-Young. Thank you for that. And thank you for pointing how this process, I like to call it a boomerang because it seems that they keep referring to one another. What domestic courts are doing really does matter for advancing their international recognition, as you have explained. So now we're going to turn to the courts to see what they're actually saying when they do speak and rule on the right to a healthy environment. So, the report addresses the fact that courts have played a central role in imbuing the right to healthy environment with meaning and elaborating the content of its substantive and procedural elements through decades of jurisprudential development. Over the past decade, particularly, the scope and content of the right evolved in a particularly interesting manner. The right has been used as a legal vehicle for expanding legal subjectivity beyond the human realm, advancing recognition and protection of the rights of non-humans and of nature more broadly. In the case of DG Khan Cement Company, the Supreme Court of Pakistan, including Justice Shah, observed that, quote, the approach of personifying the environment in order to protect and preserve nature and its objects is one of the latest evolutions in environmental law. Now, could Your Honor, Justice Shah, explain how the right to a healthy environment has been applied to advance the recognition and protection of the rights of nature? And explain what you believe the promise this approach holds for environmental jurisprudence.
Thank you. Thank you for having me, and thank you and compliments to NYU as well as UNEP for coming up with this toolkit, which I think every judge ought to read and every policymaker needs to see, because this would energize jurisprudence and it energize the courts in future. And I'm sure if it's disseminated to all the courts, it'd be very, very helpful. Just to share some of the lived experiences on how we went about in South Asia or the South, how we looked at the whole issue. First of all, I want to say that the whole issue revolves around the constitution in our country. It's a constitutionalism or environmental constitutionalism. That's how it's been framed. It's not a statutory right. It's not as if a particular environmental act is being implemented. The whole movement started off on a constitutional plane, relying on fundamental rights at that time, right to life, which eventually sort of matured into another fundamental right, which was far more potent than the earlier one, is the right to dignity. So most of our development of the environmental law as well as climate justice jurisprudence revolves around, is centered around the right to dignity, right to life, and fundamental rights. Hence, over the years, we've used our fundamental rights, amalgamated them with the international environmental principles, and kept this as a constitutional platform. This all the jurisprudence that comes out of Pakistan is in a constitutional court, not the lower courts, but the constitutional courts, because the implementation or the intervention is on the basis of fundamental rights, which get amalgamated or weaved into international environmental principles. And if you look at a number of cases that have come out of Pakistan or the South, you'll see that sustainable development, intergenerational equity, public trust doctrine, precautionary principle have been very nicely stitched seamlessly with our right to life and right to dignity. So that's been the plank on the basis of which we have been introducing and protecting the environment. Recently, the Constitution has had an amendment, and through Article 9A, right to healthy environment becomes a fundamental right in Pakistan, which was earlier recognized by the courts and the jurisprudence, but it gets recognized in the Constitution also. Talking about climate justice, the approaches or the trends have been that we've tried to, over the period of time, moved away from a very human-centric approach to environment. We thought it is important, and we've been at it for the last 2 decades also. We realized that we're talking about a very human-centric approach to environment as well as climate. And so the court has slowly moved away from that and thinking about right of nature and the dignity of nature to be protected first. If you protect the dignity of nature, you automatically protect everything else. So one is that major paradigm shift moving towards a more biocentric approach and giving rights to nature, as you just referred to D.T. Sibed. We said it's about time that personhood or legal personhood ought to be assigned to nature. Trees ought to have a right, the rivers have to have a right, and they need to be considered as persons under the Constitution because we all live in a connected world. And we cannot just think that it's all for humans, but have a more broader perspective. So that's one big experience that we've shared. The other, as I said, we've also incorporated, and we thought it was very important culturally to look at the fact that how do we reach out to people on the context of environment. So we looked at our religion and the culture also. And if you look at our religion, 80% of our holy book talks about environmental protection. And we thought it was very important to start referring to that because people could connect with it and we can achieve a lot more than just by relying on international principles, but rather on something, a text or vocabulary which people can relate to. So we've also come up with Islamic environmentalism, where we talk about the stewardship of mankind on the planet. And there's a lot of wisdom that comes out. And I'm sure other religions also talk about it. But we thought that was one other intervention that we brought about. The next thing that we thought was very important, other than this, was the fact that we were coming up with judgments one after the other, but we thought that nothing was really changing on the ground. And we thought, we just tried to realize what's wrong. We were giving judgments one after the other on climate justice, and the executive would nod in the court and say, yes, we agree, but they would not change things. Here we realized that adaptation is a totally different animal and a very costly one. So it is very easy for the government to come and accept that, yes, sir, you have given this judgment and we're supposed to adapt. But to adapt, they require a lot of funds. Unlike the Western jurisprudence, which is about mitigation, the South Asian jurisprudence is more adaptive in nature, requires a lot more to be done. So when we talk about adaptation, we require a lot of money. Hence, we thought that climate finance becomes a very important area. And we have gone ahead and held in a recent judgment that climate finance is as good as a fundamental right. If you have no access to finance, there is no way in South Asia that you can deal with adaptation. And it will be a dream, elusive dream of dealing with adaptation unless you have the money. So that's a very robust intervention that climate finance is a fundamental right in a country where, and then there are ways of mechanisms of accessing these funds, the international funds as well as local funds to deal with this. So these are some of the recent interventions that we've come about. We've also, in a recent fixing the environment, there is a case recently where a water treatment plant had to be set up and they had acquired land. A very famous river passes through Lahore called River Ravi, a very iconic river, which has been polluted over the years. And there was a plan 30 years ago to set up a treatment plant for the contaminated water of the city going into that river. So the case comes before us at the Supreme Court 30 years later, and there is no contamination, there is no treatment plant put up. And the reason given by the government was that we could not arrange the funding from the World Bank, and we still negotiated. So can you imagine, for 30 years, the river stands contaminated and there are no funds. So the judgment actually talks about homespun solutions. And that's yet another intervention that we can't just wait for, some foreign funding to arrive one day, some foreign technology to arrive one day. The South Asian countries need to look at their own cultural remedies available to deal with contaminated water. There are a number of homespun local solutions for it, which the government should have done over the last 30 years, tried one or the other, but they did not. So we've also now stressed on developing homegrown solutions to environmental protection rather than waiting for some elusive dream of foreign funding and foreign technology, which a country like Pakistan cannot afford at times. So that's yet another intervention and a trend that we must start looking at, inwardly towards answers and protecting environment. So these are some of the trends. And we, as I said, moving on towards a more biocentric approach towards the environment. Thank you.
Thank you, Justice Shah. I think particularly important of your points is that you highlight the constitutional weight that rights like the right to healthy environment and other rights have when ruling these cases, but also the importance of what actually happens on the ground in practice. And I know that the Terra team is something that has worked on, is looking to see both climate, but also particularly rights of nature as it expands as a field of law in the, at least in the Western legal systems, is to see what actually happens after these cases come down. What is the impact on the ground? So if you go to the Terra website, and also there's new scholarship flowing around that actually looks at implementation. So I encourage everyone to look at that. So moving on, the report also highlights another significant expansion in the scope and content of the right to healthy environment. That is the consolidation of a healthy climate system as a substantive element of the right. Indeed, numerous court decisions around the world affirm that the integrity of the climate system is crucial for sustaining a healthy environment. So turning to Cesar. Cesar, could you provide an overview of how courts have used a right to healthy environment to recognize a healthy climate system or similar formulations of the concept? And what duties or obligations have emerged from this jurisprudence?
Thank you, Melina. And it's really a pleasure for me to be on this panel with Soo-Young and Justice Mansoor, but also to be here with Melina as co-authors of this report, launching it in collaboration with UNEP, since we've been working on this with UNEP for a couple of years now. And of course, UNEP played a key role in along the process in instigating the research process and also reviewing and collaborating on at every step. So really, it is a pleasure to be at this stage of the process and to be putting this out for everyone to use. Hopefully, not just the report, but also the toolkit. To your point, Melina, this is it's really interesting to see how the two advisory opinions from the ICJ and the Inter-American Court of Human Rights are really the culmination of 2 decades of work by many, many individuals and organizations, intergovernmental organizations, civil society organizations, that believed that pushing forward concrete ways, concrete institutional ways, and concrete legal ways to bring together climate and human rights concerns, that all culminated in both the recognition of the right to health environment at the international level and in these two very strong advisory opinions that, to my mind, what they do is harden the otherwise kind of interpretation of the right to health environment as a soft law promise at the international level. Of course, as Justice Mansoor said, at the domestic scale, the right to health environment has been very much a binding rule and principle for a long time now. But what these two AOs did was to clarify the status of the right to health environment at the international level. And then in the case of the Inter-American Court of Human Rights, proceed to extract the logical conclusion from this recognition, which is the right to a healthy climate system. If you look at the 2-decade history, you will see, and in the book that is referenced here in the chat, Climate Change on Trial, I tell the story of that 2 decades history. Some of the proponents that states that championed the idea before the Human Rights Council and also civil society organizations would shift between pushing for the right to healthy environment, and when that was not feasible in the negotiations at the diplomatic level, they would shift to forging ahead with climate rights and climate protection. So climate and the right to a healthy environment are intertwined in international governance and international law. Going forward, what I see the two AOs and more than 500 cases that have been litigated at the domestic and international levels that use human rights arguments to advance climate action, what I see all of that process doing is 2 things. One is to clarify in the strongest term that irreversible major damage to the climate system is an obligation of an international rule that, according to the Inter-American Court of Human Rights, is even jus cogent. So the Inter-American Court gave this norm the highest possible status in international law, similar to prohibition against torture or genocide. And second, it allows governments, advocates, courts to extract consequences with regards to climate mitigation, climate adaptation, and climate reparations. And that is quite clear in the ICJ's advisory opinion. It is quite clear also in the body of jurisprudence that we analyzed in the report. So it is really crucial that it didn't focus, that those AOs and the whole body of jurisprudence that we analyzed doesn't just focus on mitigation, but for many countries around the world, especially in the global south, the key issue is climate adaptation, and more recently, climate reparations, loss and damage has rightly occupied more space in climate negotiations, but also in climate jurisprudence. So I would expect many more legal claims on adaptation and reparation to come out of these very strong statements and the body of jurisprudence that we analyzed in the report.
Thank you, Cesar, for concretizing some of these duties, and I think it will be very important to keep monitoring them and see how they develop. So another trend that the report identifies is that over the past decade, there has been a discernible shift in the profile of those invoking the right. Most notably, its use has expanded beyond traditional actors to include children and youth, increasingly so, as well as governments seeking to safeguard environmental interests. Numerous courts in Pakistan have recognized this. For example, once again, the Supreme Court of Pakistan emphasized the need for the judiciary to act on behalf of future generations' right to life, which encompasses the right to a healthy environment, as Justice Shah mentioned, and said, quote, "The great silent majority of future generations is rendered powerless and needs a voice." So, Justice Shah, could Your Honor elaborate on the role of children and youth in invoking the right to a healthy environment, both in Pakistan and, if you would like, in other jurisdictions? How have courts approached these claims? For example, what legal principles or doctrines have courts relied upon when ruling on these claims?
Thank you. I think the intergenerational equity was a principle that was going on earlier, that was in the literature. And we realized that the young ones are now really concerned about air pollution, especially in Pakistan right now, because I sit in the city of Lahore, which is one of the most polluted cities as far as smog and air pollution is concerned. So the young ones are more worried and active about it. And recently, a 3-year-old child has filed a petition at the Lahore High Court regarding smog and air pollution, and the court has interfered. As you understand, in the civil procedure, a child can approach a court through next friend or a guardian. So this child approached the court through her father and said that by the time I grow up, I'm going to be seriously unhealthy because of the smog and the air pollution. And she's right, because the air pollution and the smog that we have in the city has devastating health effects. And the court did interfere. And then that brings me to another question. So there is all this young generation coming to court. And I remember, as one of the first petitions that I had filed as a professor at the university, the entire law class was my petitioners to approach the High Court in 97. And the judgment is reported in 2006, where we had laid down a procedure and very robust recommendations on how to deal with air pollution, but nothing really happened. So that brings me to another question, and as you said, the report deals with that, and I'd like to look at that there is a huge gap between the jurisprudence that's coming out and the actual reality on the ground. So sometimes a lot of people think that our jurisprudence is showcasing a theoretical understanding of the whole matter. However, nothing is changing on the ground, and that needs to be understood. Where is the gap? Why isn't the implementation taking place? As far as climate change is concerned, we understood that it was because of the finances involved. Hence, we came up with the solution of climate finance being a right, and also, as Cesar just mentioned, the reparations and how, actually, my understanding, I could not lay my hands on a process and how do we really go approach, get these funds. The last floods that we had in 2010, we had a total balance of loss of $30 billion. Nothing has trickled in so far from any of those international funding mechanisms that we talk about. And I tried to investigate as to how does it work, and it doesn't. Now, currently, Pakistan is going through very serious floods, by the way, even more devastating than the previous ones. We haven't received anything in the last, but now we're told that the loss so far today is about $35 billion. Now, where is that going to come from? And what is the mechanism? And how would the national courts work on that account? So we've been thinking, could in the national jurisdiction, reach out to any donor and push them that why aren't they dealing with the claims filed by Pakistan on this matter? The whole thing is very hazy to my mind. I don't understand a clear process. Maybe it is intentional that way. Maybe the donors have kept it in very hazy or vague that you cannot directly reach out and get reparations. So I think the future of the entire litigation is going to be reparations. Where is going to be the money? How will it come? How will the South get money to deal with things? I think that's a huge area of litigation coming up. And secondly, we don't have the environmental science to understand. We don't have the capacity in our countries to understand how do we pin it, first of all, connected with climate change, one. And number two, how do we calculate the losses? And what's the mechanism and who accepts our position? Who is the authority that's going to go determining what's the loss or damage caused? So there's a number of areas as a judge, I think, will lead to a lot of trouble. And secondly, constitutional courts cannot go into evidence as much. So it appears that any future litigation of this sort would end up in the trial court of first instance, where judges perhaps don't have much knowledge about climate justice as such, but more so about calculating damages, calculating or figuring out how reparations ought to be arranged. So we're talking about quite a complicated area coming up where no reparations, no mechanism, no science and understanding. How do we assess loss and damage? What do we really mean by this? So I think this area needs attention, and I think we need training of our judges to understand how do we go about it. And I think the international procedure, as far as I have seen, is a bit hazy and not very clear. How do states go ahead and start getting the money? I think it's intentionally quite cumbersome, if I might add. Thank you.
Great. Thank you, Justice Shah. And thank you all for elaborating on these trends. As I previously explained, however, the report not only maps the current trends of the right, but also identifies emerging signals of change. These include the potential evolution of the right towards customary international law or jus cogens, as Cesar mentioned, the greater harmonization of the right with economic considerations, and the signal that I would like to focus on today, which is the application of the right in new and evolving environmental contexts. We have gotten a bit of a sense of that and some of the priorities that need to take place from Justice Shah, as well as Soo-Young. But Cesar, I'm going to turn to you. Could you provide examples of emerging environmental contexts in which the right to a healthy environment is gaining and should gain traction, and explain how the right may play a role in these areas?
Yeah, of course. And this is perhaps I should start by clarifying what we mean by signals of change in the report. So, as Melina said in the introduction, this is an effort to take stock of highlights of the last 10 years. Choosing the cases was not easy, first because there was no unified database of this sort, but also because the universe is much bigger than, say, the climate jurisprudence that we at the Climate Law Accelerator and others like the Savings Center have actually Savings Center for longer and much more systematically than we have done at NYU CLX in terms of compiling and analyzing climate litigation and climate jurisprudence. This universe, the right to health environment jurisprudential landscape, is much vaster. Hence, we decided to focus on those cases that seem to have made a mark in international environmental law and human rights law. And the second component of our exercise was to detect signals of change, meaning decisions that may be gesturing towards future developments that will probably be relevant in the next 5 to 10-year period. So it's not just a backward-looking report, but it tries to anticipate future trends. And I'm going to focus on two trends that we detected. One is the growing attention to the oceans. And this is, of course, not only because we're in the decade of the oceans, but also because advocates and courts have been paying much closer attention to ocean ecosystems. Most of the decisions that we looked at focused on land ecosystems, but some very important decisions focus on mangroves, on marine protected areas, on marine species like sharks and whales and others. They focus also on coral reefs. We in the report said that we anticipate that because of this growing attention to the oceans, that this will be a growing trend, and I think that's long overdue. And the second trend that's a lot more tangible already is rights to nature jurisprudence and rights to nature litigation. Justice Mansoor already alluded to some of that, and Pakistan, as usual, has been at the forefront of many of these jurisprudential developments, but also in Latin America, as many of you know, courts have been gradually incorporating attention to the more than human world in their own jurisprudence, and this trend got a decisive boost from the advisory opinion of the Inter-American Court of Human Rights, which spent a few pages to precisely that issue. And when some of us, including Melina and I, was pleaded before the court in Barbados on the occasion of the advisory opinion process, we were positively surprised to see that many of the presentations had to do with the right to health environment, as it impacts the developments on rights of nature. I personally thought that the court would not go as far as it did, but I'm very pleased to see that it did, because it opened up the door not only for an addition of a new set of rights and rights-based protections, but to a reframing of rights that moves in the direction of an ecocentric understanding of rights and of human rights as being embedded in the rights of the more than human world. That, I think, is a very timely contribution, one that I think we're gonna, if this report was written, the sequel to this report was written 10 years from now, I would fully anticipate that we would be looking at 10 years of legal innovation around the issue of rights of nature that would go deeper in the direction of protecting not only animal species, but also rivers and forests and ecosystems of all sorts from an ecocentric perspective. So that's another trend that I would anticipate and hope that the right to health environment would contribute to in the next 10 years.
Thank you, Cesar. Absolutely, I agree with you. And just to add one point, actually, looking at many of the domestic cases in Pakistan and in other jurisdictions, we see that many of these courts are actually citing to regional courts like the Inter-American Court and, of course, the ICJ as well. And so to bring it back to the first question, which was about how different courts speak with one another and how recognition matters, we see that it is really important in what, for example, the Latin American region might do and how they might expand upon rights of nature and the interrelationship between a human right and rights of nature, because then we see that ripple effect in other Supreme Court courts, for example. So definitely we should keep an eye on that and see how the courts continue to speak with one another. And last but not least, to bring it to full circle, I return to Soo-Young. So Soo-Young, despite significant progress, as Justice Shah mentioned, gaps remain in the effective implementation of the right. And achieving its full potential requires the engagement of multiple actors across sectors. So from UNEP's perspective, what are the next steps to advance effective implementation of the right? What message or guidance would you offer to the diverse members of today's audience to help them contribute to this effort and support a more sustainable future?
Okay, thank you, Melina, for the question. I was actually thinking quite a lot about the implementation. Would that be a challenge or an opportunity? But actually hearing from Justice Shah, like if we do actually have a lot of challenges for implementation, but I would think of it as an opportunity as well. So so apparently we do have actually, so we have a lot of advancement on the jurisprudential developments, but also like formal recognition of the right. But really a challenge is implementation. When I also talk to like the members of civil society and indigenous peoples, they say that they have now like great court decisions, but the implementation is like really lagging behind. So I think that's really, really a challenge. And it's something that we will have to do like in the coordination and all levels at the global, regional, and also like country level and across all sectors. But I think the momentum can continue, and also because it's a right that's driven by people and nations and courts and all the other actors demanding this right, despite the challenges. And it may not be as fast as we would like, but I think we will actually continue making progress. And maybe in 10 years, when we have the next report, if we have the next report in 10 years, hopefully we'll be able to talk about the implementation, how we made the progress in terms of implementation. So a few things I wanted to talk about the next steps. So I would say actually there are a lot of things that are going on beyond the court decisions, beyond the role of courts on the implementation of the right to healthy environment. And this report has actually touched base on a few things. So in Europe, there's a Council of Europe and I think the implementation can also tag along with these ongoing discussions and recent developments. So the regional directions at the regional level, which the Council of Europe is discussing an additional protocol on the right to healthy environment to the European Convention on the right on human rights. And also in Asia, ASEAN countries are advancing regional approaches to recognizing and implementing the right to healthy environment. And in Africa, and in July 2025, just a few months ago, African states at the African Ministers Conference on the Environment, AMCEN, it has adopted a decision requesting UNEP to support states to advance the human rights obligations related to the right to healthy environment, and also develop a continental instrument on access to environmental justice, information, and participation. So we expect a lot more regional development, the regional implementation of regional advancement and implementation of the right to healthy environment taking place also in Africa and also Latin America. The accelerated implementation of the Escazú agreement is ongoing, and hopefully that will be another avenue where we can have further implementation and effective implementation of the right to healthy environment. And on thematic direction-wise, I think the integration across environmental law, like the right to health environment integration in environmental law. So we've seen many treaties and the environmental commitments like refer to the right to a healthy environment, and also some of the commitment has really concretized the implementation of the right to a healthy environment or the human rights-based approach, such as the Kunming-Montreal Global Biodiversity Framework. And another area that I think will be really, really important is like to enhance the implementation of the right to healthy environment is a protection of environmental defenders. So we've known been known about the threats and the harassments and intimidation, and also sometimes death they face for the environmental human rights defenders. But it's not getting. I don't think it's getting any better, and they are challenging more difficulties legally, financially, and also physically. So I think defending them is essential to defend the environment and recognize and realizing the right to healthy environment. And some other key actors, I think we referred to it in the report, is like is a national human rights institution. So like there's a growing role in the monitoring and reporting on the right to healthy environment by the national human rights institutions. And currently the UNDP and the Global Alliance for NHRIs is developing a right to healthy environment monitoring tool, which aims to strengthen the capacity of NHRIs to support national implementation of the right to healthy environment. And I think these tools, such as like our tools, like will be like really practical way to implement the right to a healthy environment. And another area that I see as a gap is like data. So we've tried to fill in the gaps by producing toolkit, but I still see there's a lot of data gap on the right to healthy environment, not just on the jurisprudence, but also about like there's a lot happening in like in the universal periodic review or the treaty bodies and also other human rights mechanisms and also in the environmental negotiations. So, but then we don't have really comprehensive data and that's timely and practical. So I think that will be something that can really help implement the right to health environment further. And lastly is the action-wise, I think the full implementation of the right to healthy environment really depends on our renewed collective action across all actors and levels. As we've seen in 4 years ago today, that was really a result of everybody's work and the collaboration between states, national human rights institutions, civil society, and indigenous peoples, courts, and the UN entities. And so I think that we'll need to renew the collective action and work towards like what we can from where we are. And in 10 years, so we'll celebrate the that we all have the right to a healthy environment wherever you are and whoever you are.
Thank you, Soo-Young, for the inspirational conclusion. And so we have a few minutes left, so I would like to turn to the questions that our audience has sent to us. So we'll start with number one. We have 2 questions so far, so hopefully if you can take about 1 minute, a minute and a half, or 2 to answer, that would be wonderful. So the first one is for Justice Shah. It says, thank you for those powerful insights, particularly your point on climate finance as a right. In your view, how can courts balance judicial activism in environmental matters with institutional legitimacy, especially when decisions on climate finance or policy implementation might overlap with executive functions?
So let me just clarify that. We're very clear on the separation of powers, and we're very clear that we never enter or encroach upon the domain of policy. We think policy is something that the executive does. Even the Laghari case is not about creating a policy. The policy was there. We simply pushed it. We said, please follow your policy. So even in the climate finance, we're simply saying that finance is essential because we see that because there's been no progress at all in our judgments after judgments which cannot be implemented because there is no money, and the government or the executive seems to be depending on some foreign aid which is not coming their way. So we thought climate finance, there has to be other mechanisms of climate finance, like the Islamic climate finance is very important. It sort of really deals with this issue and can be done domestically. Things like this. So whenever we talk about climate finance, we're simply saying it's an important area. Of course, we cannot push the government to say, okay, allocate this amount of money or that amount of money. No, that hasn't happened. We, however, have noted that recently there is, under the law, there is a climate fund that the government has created, but there is no money yet in it. So the court does look at that with some sort of concern that there has to be some money. So we are very clear we never enter into the domain of policy. It is for the executive, but we can nudge the government to go in that direction, which could help improve the environment, because improving the environment is in the benefit of the fundamental rights of the people, and that's what the court is supposed to protect. So it's a circular argument. A right to a healthy environment protects people, and that's what our oath tells us to do, to protect the interest of the people and their fundamental rights. Health being one, and right to healthy environment being another fundamental right. So we're duty bound to protect it. However, we're very clear that we'll not encroach on policy matters.
Thank you, Justice Shah. And that resonates with some of the logic that we have seen in other rulings across the world. For example, with Brazil, the climate fund case that took place a couple of years ago, where the Supreme Court justices had very similar conclusions there. And so, a related question, and this one's directed to Soo-Young. What is UNEP doing to ensure access to climate finance to vulnerable countries?
Thank you. So it's a really a great question, and I actually gather a lot about there's really climate financing is really the means that we can increase the implementation of the right to healthy environment. But unfortunately, I don't have a full picture of what UNEP is doing on climate financing. But I can maybe, if I may, I can maybe discuss about my work related to financing for people. So from UNEP side, we do our best to take rights-based approach in all we do. So such as the financing also has been a critical issue for indigenous peoples. So what we have done is especially on the not climate but also biodiversity financing. So we've developed a set of principles, which is called the Core Human Rights Principles for Private Conservation Organizations and Funders. And in the development and also in the implementation and in the review of the financing mechanism for biodiversity, what we are recommending is really to make sure that that we should really try to give direct access to financing for the indigenous peoples. So this may be one way to show that how UNEP is promoting a rights-based approach on environmental issues, including financing, especially direct financing for indigenous peoples. And I'm happy to actually answer this in more detail after I speak with the colleagues who are leading this issue.
That sounds great. And I'll note that we are at time. I think to conclude our discussion today, something that I would like to personally point about the right to healthy environment, since it's a right that I have been personally working on for so many years now, is that I think it's important to not lose sight of the power that the right can have, in the sense that it continues to be a very flexible right due to its ability to evolve in response to emerging challenges, while still, on the other hand, retaining its normative clarity and legal force as a constitutional right, and potentially increasingly so as a right recognized as customary international law. I saw that there was a question about this. I encourage you to read the part of the report. I don't necessarily think that there's a conclusive answer as to whether the right is customary international law or jus cogens, much less yet, but I do believe that we're slowly getting there, particularly with judgments like the Inter-American Courts. So just to conclude, again, I think it's important to acknowledge that the adaptability of the right has not really diluted its legal clarity, but rather is a testament to its enduring relevance in the face of ecological complexity and change. So looking forward to potentially having another one of these conversations in the next 10 years to see how far the right has gotten us. Thank you very much.